most respected dignitaries on the dais, respected dignitaries of the dais, ladies and gentlemen, and most importantly, the heroes and heroines of today's function. Good evening to all of you. First of all, my warmest congratulations to each and every one of you who have been enrolled today. Best wishes to all of you. I hope you have a very, very satisfying, prosperous career ahead of you. And my congratulations to the Bar Council of Tamil Nadu for acquiring so many young, enthusiastic, talented lawyers on their rolls. The previous speakers have been very kind in speaking about me, and I'm quite overwhelmed with all the sentiments that have been expressed. Now the pressure is really on to say the right things, and I'm wondering if I will disappoint, but here goes. We started by having a few people standing on the aisles on this side. And what immediately came to mind is, one of the things that all of you as lawyers will have to do is to stand in courts endlessly for long hours. So perhaps this was a means of practice. But see, after 1 hour, they've all found spots to find a seat. And they've all been seated. So ultimately, you will all get a seat at the table and you will reach that position where you can be comfortably seated. So that's the moral of that. I am facing a room which is filled with young, energetic, talented youngsters. And this is a powerhouse of infinite possibilities. Why do I say that? There are possibilities for yourselves, possibilities for your chosen profession, possibilities for society, for your country, and for the world in general. Even 2 years ago, being a lawyer meant wearing a gown, studying your briefs for tomorrow, going to the courts, doing your work for the day, coming back, reading your briefs for the next day, and so on and on it went. But today, the possibilities for lawyers, for young lawyers poised on the threshold of starting a profession is really exciting, because it's not just practice that you have to look to. There are a whole lot of other opportunities that present themselves. Of course, I do hope that the majority of you will come into practice, because we need young blood in the profession. We want you to be part of the court scenario, to appear before us, and we want to listen to all of you, to hear all of you, to hear what you would have to say. But that apart, if practice is not for you, it doesn't matter, because there are other things that you can do as well. It's quite mind-boggling, really, the options that present themselves. They include writing your exams, becoming part of the judiciary. They include banking. You can become law officers in companies, public service, policy making, executive, arbitration, mediation. The list goes on and on. Mr. Amarraj has the unique distinction of making this a meeting with a dual purpose. He's celebrating both the cause of women today, because it is the International Day of Women Judges, and he is also conducting an enrollment function in the meanwhile. Today is the International Day of Women Judges. Does this mean that all of you are to aspire to the judiciary? Why not? But like I said, that need not be your only destination. Since we are also celebrating the cause of women today, it being very proximate to International Women's Day itself, I'll just say a few things. I've taken a cue from this, from what the previous speakers said as well. The cross-section of those who have enrolled here today is this. Total number enrolled is 1,020, of which 752 are men and 268 are women. Why have a celebration of the cause of women in a function where you have women as only, say, 1/3 of the proportion? I thought about that. And then I realized that espousing the cause of women or celebrating women is not a woman's job. It's a man's job. It is the men who have to provide the atmosphere to enable women to reach where each of you have the potential to reach. Mr. Virdale mentioned some statistics. He said that out of a total of about, I just want to make a small amendment to that. He said that out of about 1,100, which is the sanctioned strength of judges today, we have 106 women. But the 106 has to be seen qua the working strength of men judges. And that would be 786, 1/7. Still not a very happy figure. But still, it's better than 107 on 750 is better than 107 on 1,100. What do you say? Correct? Yes. So I just wanted to amend those that figure to you. But if you go to the districts, one of the earlier speakers also said that pan-India, the figure is close to about 50%. In Tamil Nadu too, we have very, very robust statistics. We have about close to 45% of the judiciary, Tamil Nadu judicial service, peopled with women. That's a very robust figure. And personally, I can tell you, in all the committees that I have been part of, whether we are recruiting law clerks or research law assistants or law assistants for the Tamil Nadu Judicial Academy or public prosecutors, whatever it may be, we find that women are putting a big fight when it comes to the positions, a very strong fight, if I may say, and they are running in majority for all those positions. It is important that men celebrate the women. It is important that the playing field is level. Swami Vivekananda said that society is akin to a bird with two wings. Men constitute one wing and women constitute the other. If you want to have society have a seamless and a smooth flight, it's necessary that both the wings must flap equally strongly. Therefore, it is important that it is not just women who celebrate women and work for their cause, but men should also do that. We have constitutional guarantees. We have government orders. We have policies that are floated by the government, by bodies, to ensure that the voice of women is heard and equal opportunity is also given to them. But these guarantees, the policies and all of it would mean nothing unless they are implemented in true measure, in the spirit with which they are implemented. Let me give you an example. You have all heard of the famous case of Vishaka versus State of Rajasthan. It was in that case that the Supreme Court had issued the Vishaka guidelines, which are to protect women from sexual harassment in the workplace. I hope all of you have heard of that. Yes, the men have also heard of it. No? Yes, all right. Those guidelines were issued expecting or anticipating that an act would come, would be imminent, paving the way for a legislation. And that judgment was rendered in 1987. But the POSH Act, or the Prevention of Sexual Harassment in Workplaces Act, came in 2013, after a gap of 16 years. So, you know, these things take time. Policy takes time, implementation of policy takes time, and in the meanwhile, it is us who have to be there for each other to ensure that every single voice is heard. And Mr. Prabhakaran mentioned mentoring. It's a very important concept today. Each of us will have to mentor. You may wonder, as a newly minted law graduate, how can I mentor anybody? I need to be mentored. That's right. We are all there to mentor you and make sure that we are here to assist you or help you or guide you in any way that you may need. But you are also to provide mentorship to those who are arriving at the stage where you have arrived now. You are to give them advice, make sure that you give them the right advice, support them in any way. I don't want to mention the methods by which you could, because that is unique to what you can do. So make sure that you provide that mentorship to those who want to reach here. We have all arrived here on the shoulders of those who paved the way for us, who made the way easy for us. And it is your responsibility now, all 1,200 of you here, to make sure that you pave the way for others to arrive here as well. Pave the way. That is as far as celebration of the cause of women is concerned. The topic for the lecture today is professional etiquette and ethics, which is a very, very important one, particularly bearing in mind various instances that have come up relating to the conduct of the bar before the courts, etc. It's important that we reiterate these principles from day one and remember it going forward. Now, the chapter 2 of part 6 of the Bar Council of India rules touch on standards of professional conduct and etiquette. And the preamble reads this. Please permit me to read. An advocate shall, at all times, conduct himself in a manner befitting his status as an officer of the court, a privileged member of the community, and a gentleman, bearing in mind that what may be lawful and moral for a person who is not a member of the bar, or for a member of the bar in his non-professional capacity, may still be improper for an advocate. I'll pause here for a minute. So what does this mean? This means that the standards of professional etiquette, of conduct, are far higher for an advocate than what it would be for any other person in society. So your standards would have to be perched at a threshold which would command a far higher sense of decorum, sense of honesty, sense of integrity, sense of conduct than an ordinary or a non-advocate may command in society. I will continue the last 4 lines. Without prejudice to the generality of the foregoing obligation, an advocate shall fearlessly uphold the interests of his client and in his conduct conform to the rules hereinafter mentioned, both in letter and in spirit. Fearlessly conform, uphold the interests of his client. This just made me remember a very interesting discussion that I had with a senior advocate one day. And this was in relation to the conundrum that these 4 lines throw up. This says that you will fearlessly uphold the interests of your client come what may. And you must do that. Every single step, you must do that. There may be occasions that will confront you in the course of your practice, in the course of your profession, when you believe that the interests of the client clash or do not align with what you believe would be right. What do you do in such situations? There would be a clash between a personal morality, the morality that the client projects. If there is a clash between personal morality and constitutional morality, the way forward is very clear. It is constitutional morality that must prevail. But what do you do if there is a clash between a morality that you own and a morality that the client projects? You will have to make a call at that point in time. This is a very interesting discussion. We came to no conclusions, even today. Luckily, in 2016, when I was elevated, such difficult questions I did not have to face thereafter. But these questions are something that you will have to resolve yourself. If there is a question like that, would you tell your client, look, this is something that I find difficult to espouse. This is something that militates against my morality. And part ways amicably, or would you say that the rules require that I espouse the cause of my client despite what my morality may be? What is the calling of your professional morality at that point in time? These are questions that you would have to answer. So bear it in mind going forward. There are 4 sections thereafter. Section 1, which talks of duty to the court. Section 2, which talks of duty to the client. Section 3, which talks of duty to the opponent. And Section 4, which is duty to the colleagues. Duty to the court is very simple. You are an officer of the court first and foremost. And you will be able to, with experience, find that balance between doing your duty to the client and doing your duty to the court, ensuring that you stay true to both. There is a duty to the opponent in the sense that you would have to be fair to your opponent. We've had instances, and our seniors tell us, we see it as well. 2 lawyers will fight in the court, and when they go out, they have their hands around each other's shoulders. That's the beauty of this profession, that there is a duty to your opponent in the court to be fair to him, and thereafter you continue your personal relationship outside of the court. Now, I could do no better than to give you a synopsis of 7 Lamps of Advocacy, which is a wonderful book written by Justice Edward Abbott Perry. Now, he talks of these 7 lamps to illuminate your paths going forward. I'll just very briefly give you a synopsis of what these 7 lamps are all about. Remember that these are lamps. So they are lit lamps, not lamps which are just there unlit. You are to light each of these lamps to make sure that they light your path going forward. The first is a lamp of honesty. Honesty is a very wide word, and we all in school learn honesty is the best policy. It is so ingrained that sometimes it becomes stale and we don't think about it with the freshness with which we have to approach it. Honesty has wide ramifications, and it covers honesty of all kinds. Not just an economic honesty or a monetary honesty. We are talking about intellectual honesty and any other kind of honesty. It essentially means integrity in what you say, in what you do. And this is, in my view, a non-negotiable lamp, because if this doesn't appeal to us, none of us have any business being here. So it is a non-negotiable lamp. The second is the lamp of courage. Fearlessness or courage, it is an adjunct of honesty. It is only if you are fearless and courageous that you can be honest. There will be instances where you have to stand your ground. You have to stand your ground either with a client, which is what I mentioned earlier when I spoke to you about there being a clash of moralities, clash of thinking, or there may be instances where you may have to stand your ground with a court. Whatever it is, whether it is with a client, your fearlessness will show in the firmness with which you adhere to ethics and morals. Sometimes, perhaps, at the risk of losing that client. In all such moral or ethical dilemmas, it is courage and honesty that must win. With the court as well, you have the responsibility to speak courageously when you know, or at least when you believe, that you are right. I want to give you a small example in this matter. As judges, we don't know everything. So when we hear a case, there are many things that we learn. The quality of our judgments would depend on the quality of the input that we get from you. So it's very important that you equip yourself well and give us the best input so that we'll be able to write better, decide things better. There was one judgment recently where a colleague of mine had said that in civil disputes, where there is a dispute between a couple, how do you divide the assets? There is only a thumb rule in these matters. There is no law on how the division of assets is to be done. If you're a student of finance or accounts, you will know that what is normally done is they will take the documentation relating to that asset, or they will take the means and modes by which the asset has been purchased, who has contributed the money to purchase the asset, and then there will be a conclusion that the document stands in this name, but in any event we have found that the sources for that asset have come from one party or another, and therefore the asset is divided. This was in a case where the husband was working, the wife was a homemaker. And a colleague of mine said that it doesn't mean that a homemaker does not contribute to the purchase of assets in a family home. And I too had the benefit of deciding that, of looking into that issue in a different matter. World over, division of assets is made more equitably. In spite of the cost of the asset being contributed by one party or the other, many jurisdictions say that if it is a couple in a marital home, there should be an equal division of assets. No, we don't have such a law here. But it was my colleague who said that in a homemaker, in the case of a homemaker, she's the one who takes care of the home, she's the one who takes care of the children, she's the one who runs the home, manages the home well. And had it not been for her efforts, it would not have been possible for the male to do what he did. So ultimately the conclusion was that there should be an equal division of the assets. So you see, these are things that go beyond what the law tells us right now. There is no specific law on this, but with this, there was a leap made in terms of the jurisprudence, which is what we want you all to do. We want you to think about things that you believe deeply in and have the courage to tell us this. Today, you may not be able to convince a bench of 5 judges. 3 may agree with you, there may be 2 who dissent. Ultimately, or 3 may not agree with you, 2 may agree with you, which will be a dissent. But ultimately, the dissent may become law. You see, that is how the law marches forward. That is how the law evolves. And this is where we want your courageous, your fearless, your confident input. The third is a lamp of industry. Hard work is a given as far as this profession is concerned. Very often we think that, when we see merit, it is an inherent quality. No, it is not. It is not in many occasions something which one is born with. It is acquired through hard work. And I remember when I joined office nearly 3 decades ago, I remember asking my senior what my working hours were. And he was very surprised. He said, working hours, all your waking hours are working hours. I don't know how many people will appreciate that today. But bear in mind that hard work, industry, and total commitment and dedication are necessary if you wish to have a quality result from your career. I don't know how many of you I'm scaring off now. I just want to say something. This generation is more aware than earlier generations were on work-life balance, on maintaining a harmony between your professional life, your personal life, and we agree. You have to maintain a balance between your professional life and your personal life because it's important. Mrs. Priscilla very rightly said, you have to take care of your physical health and your mental health. It's very important in today's times. And in order to maintain your physical health and your, or did Mrs. Nalini say that? All right. It is very important to maintain a balance between your professional health and your mental health because if you want to give your best to both your personal life and your professional life, you should have some equanimity in the way you do things. You must have a balance. So do the two militate against each other. Does achieving professional excellence mean that you have to compromise on other things? Well, that's an answer only you can arrive at. There is no one-size-fits-all solution that anybody can give you about how do you achieve that sweet spot, as you would say in your language. How do you achieve that balance between giving your best to your profession and making sure that you don't lose out on a healthy personal life as well? Work it out. Read widely. When we were talking about industry, it's important to read widely, not just about the law. The law, your work will force you to read widely about the law because you have to argue that case tomorrow. You jolly well know the law about that. But read everything that you can lay hands on. Definitely newspapers and periodicals which will keep you abreast with current events, about current politics. You don't need a political alignment, but you need to be politically aware. Because if you wish to effect changes about circumstances, situations around you, then you should know what that is in order that you can take effective action about it. Most of you would have chosen law to make a difference to society. But remember that you must be the change that you want to see. And this change will happen only with awareness of what needs to be changed. Fourth is the lamp of wit. Wit can save many a tough or sticky situation. The tip here is don't take yourself too seriously. Yes, many of the things that I say here may look like they contradict each other. But if you ruminate on it, you will know how to apply it to yourselves, to your situations, and draw the best from it. We are all here to learn and make a mark on the world, and we need to do it in a pleasant way. One doesn't appreciate aggression or rudeness, and in fact that will have negative results. Be firm but polite and self-effacing as far as possible, maintaining your dignity. That dignity and confidence will come if you have done your homework and you know that you are right in what you say. That will take you a long way. The lamp of eloquence. One believes again that eloquence is an inborn talent, but it is one that can be cultivated as well. One very obvious suggestion that I have here is, please watch lawyers. When we started practice, we had to go to the courts and then see lawyers, greats who would come down from different parts of the country, greats of the Madras bar itself. We would, after we have finished our work in the courts, we would go and sit and listen to the others, learn how they speak, learn from them what to do, what not to do, how to cultivate courtcraft. These things are very important. All of you are really privileged and lucky in one way, because you have the benefit of YouTube and you have the benefit of the internet. What you need to do is to pick on, there are YouTube series which have arguments, speeches of very great orators. Please listen to those orations. Learn how you can be concise and effective. What a judge does not like is a long, meandering argument where a lot is said with nothing said. That's not something which anybody would appreciate. You need to learn how to speak concisely, and speaking concisely is eloquence by itself. Equally important is that you join professional organizations, study circles. You are just starting out. So I would not say immediately join an IPR organization and learn only about it. You can join an IPR organization or join a revenue bar association, or if you have a particular interest towards a particular subject, by all means cultivate it. But very important that you attend lectures that the bar associations will conduct amongst yourself. Please have study circles so that you can deliberate and analyze on what case somebody else did, what did you do, share your notes, share your thoughts, so that your knowledge of the subjects becomes wide. I just have 3 suggestions to make, suggested readings. One is, you can make a note if you would like. One is Professional Conduct and Advocacy by K. Krishnaswamy Iyer. I think the library will have it. Bar Council, on the last occasion I spoke also, I requested that they keep adequate copies in their library. This is not a book that is available online, but the Bar Council could consider keeping enough copies available so that you can read that. The second is The Golden Rules of Advocacy by Keith Evans. Of course, this will have a British approach and an American approach. But like I said, read wide so that your knowledge is a mile deep, not an inch deep and a mile wide. That's the difference. So please read about all other jurisdictions so that you can improve your knowledge as well. And the third is The Legal Mind, an Approach to the Dynamics of Advocacy by Gerald Abrahams. If you have the time, please read these books. They will help you to hone your speaking abilities, to hone your advocacy skills, and to help you to speak concisely and think on your feet. The 6th is The Lamp of Judgment. This is a lamp which is to cultivate a keen sense of what is right and what is wrong, so that you develop your own unique brand of fairness. When somebody says you're not being fair, it is from their perspective, because they have an idea of what is being fair. And when somebody says something, they believe that that militates against what I believe is fair. But there is what we call a universal sense of fairness. So the lamp, this lamp is to caution you to develop a unique sense of fairness, so that you're able to appreciate justice in all its contours. You know, I was not able to find a definition for the word justice. Why? Because what is the definition of the word definition? The definition for the word definition is to limit the expanse and meaning of a term. So if I define something, I am limiting it. You know, as lawyers, you have exhaustive definitions. You've got enumerative definitions, but still illustrative definitions. But when you define something, you are essentially trying to pigeonhole it, to put it into something and say, these are the contours of what this is. And justice refuses to have that done. Justice is not a term that should be limited and fenced in, but it should be let free in full glory. Perhaps that is the reason why I don't find a definition for the term justice. If there are 1,300 people in this room, there would be 1,300 opinions on what is right, what is just. Of course, I hasten to add that they must conform to a universal sense of what is fair, what is right, what is just. The seventh is the lamp of fellowship. Don't become unidimensional and so focused on your work that you get cut off from family and friends. Continue to cultivate your interests and your hobbies. Please have a healthy mix of friends both within the profession and out of the profession. Within the profession, yes, because you will have your own personal friends within the profession. You will also have friends who intellectually stimulate you, who talk to you about subjects that you are interested in, who talk to you about other subjects, who open up other different vistas. So those will be your professional friends and associates. You will also make sure that you keep in touch with your own school friends or your whoever your close circle of friends are. I have a close circle of friends who are musicians, because that's one of the things that I love. You may join a book club if you love books. Make sure that you read non-law books as well. So this lamp would achieve two objects: this fellowship as well as improvement in the study of the law, depending on where your circle of friends are. I said 7 lamps of advocacy. I found some articles online which added an 8th lamp, and that is the lamp of tact, T-A-C-T, develop tact. This is an add-on, and this is something that you will develop over time, how to be tactful. Some of us never develop it. And if you ask me, there's nothing wrong with that, because being blunt, honest, and tactless is better than being a diplomat whose word cannot be trusted. So, well, that's an optional lamp, if you ask me. If you wish to develop tact, but can still remain honest but tactful, please do, by all means. Now, the dedication in this book is a very interesting dedication. The author says, I dedicate this book, and I quote, to the 9th circuit where I have learnt these things. What does that mean? These 7 lamps are not lamps that touch so much on the law, but on life. Therefore, these are things that you will learn going forward. What you're entering today is not just a profession. It must become a way of life. Everything that you do would somehow attune you to a proper, appropriate, robust, and beautiful lifestyle where the law will be the cornerstone. And this development of justice, this understanding of justice that I said, that will happen, that will blossom over the years as you practice. I just have 2 words that I thought were important that I just wanted to place before you. One is, am I taking too long? I have another 5 minutes? Okay. The first is the word expectations. You've all heard of Stephen Hawking, the renowned theoretical physicist. He was born in 1952, and when he was on a brilliant career path, he was diagnosed at 21 years with motor neuron disease. He didn't let that deter him, and he went on, as you know, he went on to achieve what he did. On expectations, this is what he said, and I quote, "My expectations were reduced to zero when I was 21. Everything after that has been a bonus." And for your information, his greatest discoveries, theories, and all his awards have been after the age of 21. So what I wanted to say is, just go into the profession with the greatest of aims and goals, but don't expect anything which you may feel, if I don't achieve, I am going to be disappointed. I want to draw a distinction between an expectation and a goal or a vision. You must have a goal, a rough idea as to where you want to travel, and you must set high standards for yourself. But keep your expectations realistic. This will become very important to sustain your confidence along the way. And the second thing that I wanted to say was choices. Please think about the choices that you make along the way. Again, there can be very little that one can say on choices in a general sense, because they are very personal. Choices are personal. Make the choice that fits you the best. Never stop learning. Sometimes I do wish that I had been a better, more attentive student when I was in college. But you know, one of the silver linings of this COVID pandemic was that one of my family members was studying in law college at that time. So their courses were all online. So in fact, during the COVID pandemic, I took an optional course that the child was taking in my house. And I used to go fully armed with a notebook and a pencil and with all the previous reading done, to such an extent that the child used to tell me, "I think you are better prepared for this class than I am." So enjoy learning. Don't stop learning and enjoy it. There's a joy in keeping your interest in the subject alive, and never let that sag. The last thing that I wanted to say is, there is an elephant in the room, and that is the fee or the money that the profession will give you. You know, money, it's not a bad thing. You're here to make sure that it is a profession after all. It's not a service. And it is important that you are remunerated well for what you do, as long as you are aware that there's a fine line between avarice and charging right or charging appropriately. So please bear that fine distinction in mind. I was just asking the Bar Council members, there was talk for a long time that there should be some, those of you may want to start straight out by yourselves, in which case what I said now would be relevant. Those of you may join offices and find that you wish the remuneration was better. So there was a suggestion made to them that there should at least be a minimum fee fixed. And one of my colleagues has passed an order fixing some minimum remuneration for the salary for the advocates. We will not deliberate on the appropriateness or otherwise of that. Bear in mind that, in fact, Mr. Prabhakaran said that you're not here for the money, he said. I want to quote him. He said, "You are not here for the money, you're here for the joy of the subject, for the beauty of the profession." Yes, I couldn't agree more. But we have to take ground realities and the practical side of the matter into our mind as well. So that will happen, you know. With excellence will come the rewards. So what I want to say to you on that is, focus on the excellence. Don't focus on the rewards. If you focus on the excellence, you concentrate on your job, with excellence, things will pan out and the rewards will come in time. Well, I think I've taken, I have more material to share with you, but I think I've taken a lot of your time. Thank you very much for a patient hearing. Again, my congratulations to each and every one of you, and my best wishes to all of you.